to our judges.
Hello, Idaho. My name is Ed Murphy. I'm a Superior Court judge in neighboring Tacoma, Washington. I want to congratulate you on making it to the national finals and look forward to your presentation here this afternoon. And I'm going to have the other judges introduce themselves as well.
I'm Edward Volpe. I'm an attorney from Denver, Colorado, and I congratulate you on your hard work that has gotten you to the national finals. I'm very anxious to hear your comments with regard to this question.
Hi there, I'm Caitlin Johnston. I am an attorney in New York City. And when I was in high school growing up in Indiana, I was a We the People participant. So I know what it's like to be in your shoes, but I never made it to nationals. So you have already bested me, and I am very much looking forward to hearing your remarks today.
So I would ask the students to introduce themselves and their teacher or coach.
All right, hi, I'm Emma Redmond. I'm a junior here at Meridian Medical. And then our teacher is Mr. Godet, Blake Godet. Yeah.
I am Madison Healy. I am also a junior at Meridian Medical.
My name is Addie Barker, and I'm a junior as well.
My name is Logan Jolette, and I'm also a junior.
All right, lots of juniors. So as you probably know, the question that we're dealing with today is from Unit 5, number 1. I'm going to read the question, and then once I finish reading, a result of the decision in Wisconsin v. Yoder is that any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the United States Constitution or in state constitutions that protect the right to an education? How have courts balanced religious beliefs with other rights? And you may begin.
We agree with the decision that a parent or guardian can refuse to let their children go to school or take certain classes that go against their religious beliefs. We believe that the decision to withhold students from attending school should be made within the family according to their individual religious beliefs. When the government tries to prohibit your religious beliefs, it infringes on your listed fundamental rights. If a parent decides they want to pull their student out of school, there are alternate ways of one to be educated. The Amish don't believe that their students should attend public, private, secular, and non-secular schools. However, there are options like homeschooling that a parent can take into consideration. While the Yoder case was open, the parents adequately presented their alternate mode of continuing informal vocational education in terms of overall interest that the state relies on in support of its program of compulsory high school education, thus demonstrating that they have indeed continued education with their children. In certain states, they have religious release programs built within the schools. Students of all religions are allowed to be released for one period during the school year. They don't receive any credit towards their the graduation progress, but they are allowed to leave to practice their religion. We see that schools are allowing students off campus early in order to practice their religions.
The right to an education, specifically the Equal Protection Clause. The clause ensures that all students can receive equal education. The most prominent example of this would be in Brown v. Board of Education. The Equal Protection Clause was used to argue that separation was inherently unequal, and the case gave people of people of all races equal opportunity to receive an education. The case Plyer v. Doe also used the Equal Protection Clause to protect the right to an education, this time for undocumented immigrants. The justices ruled that although the students weren't citizens of the United States or the state of Texas, they are still people and therefore are protected by the 14th Amendment and needed equal funding in the schools they attended. While there is protection of education in the federal Constitution, it is mainly left up to the states. The Idaho State Constitution, we see the protection of the right to education in Section 9 of Article 9, which reads, "The legislature may require by law that every child shall attend the public schools of the state throughout the period between the ages of 6 and 18 years unless educated by other means as provided by law."
It is rare that we see forthright limitations on religious beliefs to balance other rights. As Justice Sandra O'Connor argues, the government can only infringe on religious liberty when a compelling interest exists to do so. In cases of balancing between religious beliefs and other rights, we often see education at the forefront. Yet an additional right that has been balanced with religious beliefs has been the right to health and broadly the right to life. This has been observed in cases like Prince v. Massachusetts. This case discusses the limits of religious freedom when it comes to vaccinations and public health. The Supreme Court had ruled that a parent cannot claim freedom from compulsory vaccination for the child more than for himself on religious grounds, and that the right to practice religion freely does not include the liberty to expose the community or the child to communicable diseases or ill health or death.
We've also seen similar rulings in lower courts, such as State v. Legally in the Court of Appeals in Oregon. On the opposing side, the Supreme Court has ruled in favor of religion over aforementioned freedoms, like in Burwell v. Hobby Lobby stores. In said case, the owners of Hobby Lobby challenged the ACA's requirement that employment-based group healthcare must provide preventative care, including contraceptives. They claimed that it violated the Free Exercise Clause of the First Amendment, as well as the Religious Freedom Restoration Act of 1993. The Supreme Court ruled in favor of Hobby Lobby, quote, because the contraception requirement forces religious corporations to fund what they consider abortion, unquote, thus reestablishing how freedom of religion has been balanced not only with public health, but with healthcare.
All right. I'd ask you to put away your notes and we're going to ask some questions. How have we been instructed by the courts to analyze laws that have an impact on religious beliefs?
So in the First Amendment is where we see our protection for the right to practice your religion. And so when we're talking about the ways the government can kind of get involved in that, you have to make sure that any laws made do not target one specific group of people or one specific religion, and that it is applied equally to all. So for example, if a certain religion uses drugs in their services, and someone gets in trouble, like at work, like at a drug test, that does not infringe on their right to practice their religion, as long as that is also applied to people regardless of their religion, and it is equally applied to all.
And then just carrying on with what Addie had mentioned, at the end of my prepared response, I talked about religious release within schools. And so here in Idaho, we have a lot of seminary where students get released to go over to their temple that is right next to the school. Schools also have to make exceptions for those who are Catholic, Christian, and like practicing Muslim religions. They have to allow that release for every student, not just someone who is going over to a temple that's on school grounds, because there aren't always other religious sanctuaries or buildings around the high school.
In terms of the separation between church and state, may states or cities display religious symbols that favor a particular religion, such as the creche or the manger scene on courthouses during the Christmas season, or with regard to posting the 10 Commandments in courthouses or in schools? Are those kinds of displays allowed, given the wall of separation between church and state?
Personally, I believe that as long as they allow like monuments or whatever from all religions, then it should be okay. Like, I can't remember which state it was, but there was a courthouse that had the 10 Commandments posted outside, and the Church of Satan, they were going to have a statue of, I think, Baphomet put outside also. And there was a lot of disagreement, but I feel like it should be allowed, as it would recognize, well, it wouldn't recognize that religion, but it would treat all of those religions equally, and it would allow religions to have religious iconography in public spaces.
I just want to counter that. I think that this could open for a lot of controversy within the state, especially if they are giving each religion like that like keepsake on that ground. It might cause some controversy, because what if one is presented more, or it is at the forefront of all of them and you're not seeing the other ones, they're not presented as much. I think that could cause issues. And then if that is the case, it might seem like the government or the political affiliation in office is taking a religious side more heavily if one is presented in a more like extravagant way.
So you mentioned that you agree with that the decision to withhold children from school belongs to the parents. How do we weigh when the child's right trumps the parents' religious beliefs? And let me give you an example. What about an ultra-conservative religious sect that wants to marry off young girls to be married and have children before they are 18? How should the court deal with that and weighing the parents' religious views against the child's interests?
I'll start off. I think that that is a really good point that you bring up. Those are two totally different like subjects that we're talking about, though. We're talking about education and then basically like giving someone away, and they're still underage. So we do have those laws in place that like if this person that they were being married off to was older than the age of 18, this is now not a case of, well, it depends on like state by state and everything, but I think that these are two different topics that we're talking about here. I think that education is much different than marrying a child off. We see in the Amish communities, they do let their children go out at a certain age to experience the real world, if you will. And it has been proven that 90% of the children do return to the Amish communities not in order, but to carry out like their family's duty and to essentially farm for the rest of their lives, because that's what they believe that their like religion is here to do. And they're like providers within their own community. So it is proven that these students do, or these children do come back. But I do think that the point you bring up, when does the student have a say? And I think really that is when they let those children out into the real world to experience that themselves.
And even when children are taken out of public school and they're homeschooled or have an alternate way of schooling, they still have to meet certain criteria to the state to be allowed to continue that. So that will help ensure that even if children aren't in the classroom with all these other kids learning specific things from teachers, that they're still learning what they need to learn in order to be successful.
So is it this panel's view that until a child is 18, the parents are in total control, absent those standards that you just said, Addie?
I think that we kind of agree that the parent should have most control. I think that there should still be a discussion between parents and children. Obviously, that isn't something that the state is necessarily going to be like watching over to see how much of that is from the child and how much of that is from the parent. But I think that, yes, I think the parent should have more control up until the child does turn 18.
Also, can I just jump in there real quick? You know, if you look at children when their parents get divorced, the kids don't have a say in like who they live with. It's mainly the court's decision and the court rules on where that child goes. And then the parents, in turn, after that ruling, will make all the decisions for the child. The child really has no say in that particular situation until they are a certain age. And most of the time that is 18. Like, hey, parents will have to pay child support until that child is 18. They are still like the guardian of that child. And so I think that that is very similar to this scenario where they are still that child's legal guardian until they turn 18. And so they are to make the best decision.
And this obviously varies, but to kind of counter what Maddie was saying, a lot of courts do take into account, if the child is old enough, they do take into account child opinion on which parent they would like to stay with in divorce cases. So we do see some like legal recognition of the opinions of children, but that obviously depends on a lot of circumstances.
Is there a place in the Yoder decision for the consideration of what the child wants? Should that be considered at all?
I would like to say that I think that because it's a family decision, and what we saw in the Yoder case, it was based on a community decision. I think
You
that
can
it's
finish, go ahead and
okay.
finish your
Okay.
thought.
I think that the Amish community is very much community based. And so I think that inevitably the child's opinion is included in that, and the well-being of the child is taken into consideration. So I'd say yes.
Okay. All right. Take a deep breath. You made it. Congratulations. Well done. Really enjoyed listening to what you had to say. And one of the things that struck me most in listening to you was that you did a good job of describing your own personal beliefs and taking ownership of your thoughts about these different issues. And we hit you with a lot of different issues outside of just looking at specifically the Yoder decision, trying to get you to think about the application of some of these concepts to other aspects of your lives, because you are going to be a generation that lives under these decisions and changes these decisions. And you are far and above where not only just kids at your age, kids in high school, kids in college, but most people in this country, as far as your knowledge of the Constitution and civics. And so you are going to be the leaders, whether you're in a leadership role or whether you're living your life in some other capacity. You are going to be the leaders of this country. So that's why we ask you these questions, to kind of push you a little bit. But I really appreciated you giving us your thoughts and opinions in regards to that. So well done. Thank you.
I too enjoyed your comments. I always enjoy hearing what students of your age have with regard to your opinions, particularly after you study in a civics program as sophisticated as the one you're in. With regard to your presentation, I thought you did a good job of saying you agreed with Yoder, but you did feel like the family and the students themselves should have some rights. You pointed out that there are states that allow children to be withdrawn from school, public school, on the basis of religious belief, but generally those laws require certain minimum standards of follow-up education. They are not simply, with the exception of Yoder, there is some pressure to provide out-of-school education to those students. And that applies to private schools as well as religious schools. I thought you did a good job of bringing up Brown v. Board in terms of equal protection. I do think that is applicable here. And you pointed out that that applies not only to citizens, but to illegal alien children, because the 14th Amendment says you shall not deny to any person, not citizen, but person, the rights conferred by the state. Thought you did a good job on Burwell versus Hobby Lobby with regard to the contraception issue. And I thought it was interesting that you talked about divorce and how the court might listen to children as to what their preference might be in terms of living with one parent and not the other. With regard to my question on religious displays, that has been a long-running issue with regard to separation of church and state. You referenced the holdings in some of those cases. I would refer you to McCreary County versus ACLU, which held that the display of the 10 Commandments in a courthouse stairwell was an improper endorsement of a particular religion, obviously Christianity. And you talked about the fact that in the course of that case, a non-Christian sect wanted to have their own symbols displayed. And that issue was raised in Park City versus Sumum, in which a non-Christian group wanted to have one of their monuments put into a park full of monuments with regard to religious symbols. But the Supreme Court came up with the concept of a state has the right to free expression, and therefore they don't have to include the symbols of all separate religions in a park that they have established. But I enjoyed hearing from you. I enjoy seeing the hard work that you have done these 2 semesters. Congratulations to you and to your teacher.
I echo that. Great job. I think you all brought a ton of energy to, especially the follow-ups and just kind of being willing to dive in and give your take. I don't think there was any question that you shied away from before you jumped in and built on each other. I will say, you were able to quote the holdings of some cases, even though you couldn't remember the names. I actually think that's pretty effective because I'd rather understand why you're citing something than just the fact that you remember the precise case. It's a cherry on top if you do both. But we could clearly tell that you knew the subject matter. I think it was Smith that you were reaching for there, Logan. On my question, I threw you a little bit of a curveball, and I wanted to see how wedded to your position you were, and you really stuck with it there, it seemed. And I don't know if that was a strategy or if that was you were just trying to get that. Maddie's laughing, so I don't. Well, I guess remains to be seen. I wanted you to maybe go for the Vax case, the Prince case that you cited, and say, well, is there a danger to the health of the child? Is this abuse? Right? If you read some of the stuff on the Heritage Foundation website, I mean, her whole theory is that they don't want their children in school past 8th grade because they're using them as forced labor to tend the farms, and that religion was a pretext. And I think that, obviously these are issues that the court has had to tangle with. There's no, easy answer here. And so you can get down to just telling us how you'd analyze those things and letting us help you think those things through. And it's okay to contradict yourself if you get down a line of reasoning and you say, maybe right. But I do think it is a strategy to stand by your position. So I understand that. And great job just engaging with us. You guys were total pros.
All right, we want to give you guys a round of applause for your great work. And also, I want to put on the official record, I neglected to put up the 1-minute sign during your prepared statements. That was my fault, judges. And so I want you to know that their presentation fell right in that 3 minutes, 50 seconds. It was kind of awkward because I didn't put it up. And so I think maybe you were thinking it was really short. It wasn't. That was my fault. They were right in there. My first one of the day. I apologize, Idaho, but you guys, you won't get dinged for that.